Now let's take chapter 3 of company law. We've so far done chapter 1 and chapter 2. We move now to chapter 3 of company law, where we will be looking at membership of a company. Before we take the discussion forward, it is important that I show you what you are supposed to go to with respect to chapter 3. My name is Mr. Williams of Fatima Training Institute, Center for CIFA Studies. My contacts are 0727 871093. Let me show you what you should go to as far as chapter 3 of company law is concerned. We will go to acquisition of membership, register of members, rights and liabilities of members, cessation of membership, register of a company's beneficial owners, and derivative actions. In most of the company law chapters, you will find a specific case which is associated with that particular chapter. In chapter 1, we came across the case study in Salmon versus Salmon, as well as the case in Makaura versus Northern Assurance Limited. In chapter 2, we've seen the case study in Ashbury versus Richard, as well as the case in Bamboo Press, in explaining the concept of lifting the veil of incorporation as far as take over bid is concerned. Now, in this chapter, you come across another case which is known as the case in Force versus Abuto. Now, before we move on, allow me to show you what is expected of you as far as chapter 3 of company law is concerned. Company law chapter 3 is about membership of a company. You will study acquisition of membership, that is, how do you become a member, register of members, rights and liabilities of members. Under that subtopic, that is rights and liabilities of members, that is where the case in Force versus Abuto comes in. Then cessation of membership, register of a company's beneficial owners, and then derivative actions. If you have this study text, you'll always find a collection of past paper questions from that specific chapter from 2020 up to 2015. Right, having in mind what we are supposed to go through or what we are supposed to study, we now look at acquisition of membership. So this chapter is quite It's not very detailed, it's quite a small chapter, however, quite examinable. We should look at acquisition of membership. Now, in this case, when we talk of a member with regard to companies, a member simply means the shareholder. Even though the Company Act does not define what a member is, but simply anytime we talk of a member with respect to companies, we are simply talking about the shareholders. Now, I will present to you 7 ways of becoming a member with respect to companies. So we look at acquisition of membership. Acquisition of membership. Acquisition of membership is what I want us to look at. That is, how do you acquire a company membership? How do you become a shareholder, whether it is for a private company or for a public limited company? So far, we've done types of companies, and if you do not have that class so far, you can just get to our YouTube, Fatima Institute, you subscribe and you will get that discussion there, quite detailed and elaborate. Well, I will now discuss acquisition of membership. How can you acquire the membership of a company? In other words, how can you become a shareholder in a company? Now, that for the sake of examination, you should know the ways of becoming a member and explaining the meaning of the same. I'll first present to you 7 ways of acquiring membership of a company, and then I will discuss each one of them at a time. Now, you can first write them very fast, and then we discuss them together. Now, 1, as it appears there, acquisition of membership. How do you become a member? 1 is subscribing to the memorandum of association. That is 1. If you are writing, first write the ways of acquiring membership of a company. You write them down, and then I will discuss them with you. So 1 is subscribing to the memorandum of association. Number 2, by application and allotment. Number 3, transfer from an existing member. Number 4, transmission on death of member. Number 5, transmission on bankruptcy of a member. I believe you have written those 5. First of all, you write those 5 ways of acquiring membership, and then you move to next page, and that is number 6. The 6th way of acquiring membership is compliance with section 182 subsection 2, and number 7, by estoppel. So write that, and then we discuss the same. So you can pause your video and you go through that before we take up the discussion. Now, acquisition of membership. We've said membership or a member simply means a shareholder. A member means a shareholder. So how do you become a shareholder with respect to companies? 1 is subscribing to the memorandum of association. That is 1. Subscribing to the memorandum of association. I mentioned earlier that Section 28 of the Company Act does not define the word member. Rather, it states the ways in which a person may become a company member. A person may become a member of a company in one or more of the following ways. These are the ways in which you can become a member of a company. And I have said that member means a shareholder. One is subscribing to the Memorandum of Association, MOA. In Chapter 2, we've covered the constitutive documents, and one of them we say is the Memorandum of Association, MOA. We define MOA as the external constitution that governs the relationship between the members of the company and the outsiders. We looked at the contents of MOA, like the name clause, the capital clause, the limited liability clause, the object clause, among others. So we've done the Memorandum of Association and we know what it really is. So here, one of the ways of becoming a member of a company is subscribing to the Memorandum of Association. And you say here, Section 28, subsection 1 provides that the subscribers to the company MOA shall be deemed to have agreed to become members of the company, and on registration of MOA, their names shall be entered in the register of members. So that is it. In the process of forming a company, we've done the process of company formation from name search up to certificate of incorporation. So within the process of company incorporation or the process of registering the company, there are those names which may appear or will appear in the Memorandum of Association. So such names or those names appearing in the Memorandum of Association will be deemed to be members of that company. They will be deemed to be shareholders automatically. So if your name is in the Memorandum of Association, then automatically you will be deemed to be a member of that company. So that is, you can become a member, you can acquire membership of a company by subscribing to the Memorandum of Association. That is one. Number two, the other way of becoming a member is by application and allotment. So once a company has been incorporated, usually the company will invite members of the public to apply for shares, to subscribe, or to apply for the shares of the company. The invitation through the prospectus, by the company to the members of the public to purchase the shares of the company. So if you apply for these shares and you qualify for the same, you are allotted these shares, and then by so doing, you will become a member of the company. You become a shareholder. So simply by purchasing the shares of a company, you purchase the shares of a company, by so doing, you will become a member or a shareholder. So here, number two is by application and allotment. So the other way of acquiring membership is by application and allotment. And you say, when a person applies for the shares and the shares are allotted to him, he becomes a member and his name must be entered in the register of members. Simple. By application and allotment. Number three, transfer from an existing member. So we'll be looking at the difference between transfer and transmission as we move forward. But at this level, understand that transfer of shares, if if I purchase the shares from an existing member, then if because there can either be maybe full transfer or partial transfer. If it is a full transfer, then the existing member will stop from being a member and the new purchaser or the new transferee becomes a member. So this is occurring where we have an existing shareholder that is an existing member who is willing to sell the shares to a new member or a new shareholder. So in that case, the existing member will stop from being a member and the new purchaser becomes a new member. So by transfer from an existing member. So a transfer is a purchase of shares from the company's shareholder and not from the company itself. So note here, the transfer. You are purchasing from existing shareholder and not from the company. Not like as in the case of IPO, that is initial public offer. So in this case, where there is a transfer, you are purchasing the shares from an existing shareholder himself or herself, not from the company. So transfer from an existing member, you say a transfer is the purchase of shares from the company's shareholder and not from the company itself. When the shares are transferred to the transferee and the transferor is approved by the company, the transferee becomes a member and his name is entered in the register of members. So point number 3 or method number 3 of acquisition of membership is transfer from an existing member. Number four, method number 4 of acquiring membership is transmission on death of a member. Transmission on death of a member. So an existing member passes away. So what happens as far as the law of succession is concerned? Who is supposed to take over these shares? If an existing member passes away, there are legal procedures to be observed because a person who has passed away cannot continue to exist in the register of members as far as the operations of the company is concerned. So, transmission on death of a member. Transmission is a legal process by which ownership of shares in a company changes automatically on the death of a member to his personal representatives. When a member dies, his name is deleted from the register of members and that of the personal representative is entered in the register. The personal representative will administer the shares of a deceased member, after which he will transfer the shares to the legitimate dependent of the shareholder. So that's transmission. At this point, note the difference between transfer of shares and transmission of shares. Transfer of shares is voluntary. Transmission of shares is not voluntary. It occurs if maybe a person passes away or a person is bankrupt. So point number 4 simply is transmission on death of a member. Number 5, the other method of acquisition of membership is transmission on bankruptcy of a member. So bankruptcy again will result to transmission, not transfer. Upon being declared bankrupt, the shares are transferred to the trustee in bankruptcy. So once you become bankrupt, if you are an existing shareholder and you have become bankrupt, what will happen is that those shares will be transferred to the trustee in bankruptcy. Method number six is compliance with section 182, subsection 2. A person who has consented to be a director and has given a statutory undertaking to take and pay for his qualification shares is declared by section 182 subsection 2 to be in the same position as if he had signed the memorandum of association. So compliance with section 182 implies that you become a member once you have acquired the qualification shares. You can't become a company director without acquiring a certain percentage of shares of that particular company. So compliance with section 182 subsection 2 is whereby we are talking about a director having acquired a certain percentage of shares in that particular company. And lastly, by estoppel. By estoppel, a person who, without having agreed to be a member of the company and is aware that his name has been entered in the register, but takes no steps to have it removed therefrom, may be stopped from denying his upright membership to somebody who relied on it and extended credit up to or extended credit to the company. So your name is in the register of members and you know that, while in actual sense you are not a member. Assume, for example, that your name is in the register of members by mistake. Your name is in register by mistake and you know that. So somebody may rely on that information that you are a member. So in that case, you are a member simply because your name is in the register, whereas in actual sense, you are not a member. So in that case, you are a member by estoppel. So that is ways of acquiring membership. These are the ways of acquisition of membership. So one, you have said subscribing to the memorandum of association. Number two, by application and allotment. Number three, transfer from an existing member. Number four, transmission on death of a member. Number five, transmission on bankruptcy of a member. Number six, compliance with section 182, subsection 2. And number seven, by estoppel. That's quite important as far as examinations are concerned. I will now present that to you, and you can take your notes. Take your notes. Acquisition of membership now. You can just maybe pause your video and you go through that. Subscribing to the memorandum of association. You can read the meaning, number one. Number two, by application and allotment. Remember, we are talking about acquisition of membership. How to become a member is what we are starting with here. Acquisition of membership. So subscribing to the memorandum of association, we go through that. Number two, by application and allotment. Number three, transfer from an existing member. Number four, transmission on death of a member. Note the difference between transfer and transmission. You say transfer means voluntary. Transfer is voluntary, whereas transmission is not voluntary. Transmission may occur in case of death or bankruptcy. So transmission on death, transmission on bankruptcy of a member. Then number six is compliance with section 182, subsection 2, and number 7 is by Estopel. So that is it about acquisition of membership. That is it about acquisition of membership, how to acquire company membership. Now, acquisition of membership, we are through with that. We move to register of members. Okay, we go to register of members is the next thing. We are through with that. So you go to register of members. So next part, register of members. We are moving to register of members. I'll show you that. Register of members. Now you can first go through that. What is in our book? Register of members. You can check that. Check my notes here. Pause your video and first go through register of members, what it is, before I just move very fast. Register of members, section 112, subsection 1 of the Company Act states that every company must keep the register of members containing the following details. So company register must have these details. 1, full names and postal address of the members. Full names and postal address of the members. Number 2, the number of shares held by each member. Number 3, amount paid or agreed to be paid as the consideration on the shares of each member. Number 4, the date at which each person was entered in the register of members. And number 5, the date at which a person ceased to be a member. Those are important details that should be contained in the register of members. The register must be kept at the company's registered office and must be available for inspection during normal working hours. If there is a default in keeping the register of members, any officer in default shall have committed a criminal offense. The register of members is the document of title and not the share certificate. The share certificate is a mere acknowledgement on the part of the company that the name of the person mentioned on it is duly recorded in the register. We look at maintenance of a register. Maintenance of the register. Under section 112, subsection 2, the register must be kept at the registered office of the company. However, if the work of making it up is being done in some other office of the company, it may be kept at that office. Number 2, if the company has engaged a third party to make up the register on its behalf, it may be kept in that person's office. And number 3, the register of members must not be kept outside Kenya. So maintenance of register of members, the point here is that the register of members, that register containing the names and all the details relating to the shareholders, must be kept at the head office of that particular company. However, there are circumstances under which the register of members can be found elsewhere. So these 3 points here, they explain circumstances under which the register of members can be found in a different place other than in the registered office. You can check that, and you pause your video and you take your notes. Pause your video and you take your notes. That is maintenance of register. So customarily, you expect the register of members to be kept at the registered office of the company. However, under these 3 circumstances, the register of members may be found in a different place other than the registered office. We move now to rectification of the register of members. Rectification of the register of members. Rectification. Right. You can just go through this relating to rectification. You can just check this rectification, which you find in section 118, subsection 1, rectification. Then you look at closure of the register and then inspection of register. So check that. You pause your video and you go through that. Now, with respect to rectification of the register of members, section 118, subsection 1 of the Company Act empowers the High Court to rectify the register of members in 2 ways. So there are 2 ways in which the High Court may rectify the register of members. 1, if the name of any person is without sufficient cause entered in or omitted from the company register of members. So that is 1. In that case, if the name of a member is omitted or it is wrongly entered in the register, then that name should be removed if it is entered in the register by mistake. As you have seen, with respect to acquisition of membership, we've said one of the ways is by estoppel. That is, your name is in the register by mistake. So, should that name continue to be in the register, if the company has come, if the attention of the company has been drawn and known that this particular name is in the register by mistake, that name should be obviously removed from the register. So in that case, by removing that particular name, what we are doing is that we are doing rectification of the register. Alternatively, if the name has been omitted from the register, the High Court then should ensure that that name has been entered in the register of members. So in that case, there is rectification of the register of members. And that is where we are saying that section 118, subsection 1 of the Company Act empowers the High Court to rectify the register of members in 2 ways, namely 1, if the name of any person is without sufficient cause entered in or omitted from the register of members. Number 2, default is made or unnecessary delay takes place in entering in the register the fact of any person having ceased to be a member. So you cease to be a member, maybe through death or through bankruptcy or through whatever reason, but your name continues to be in the register of members. In that case, the High Court has powers to ensure that that particular name is removed from the register. The application to the court to rectify the register may be made by, so these 3 people can make application to the High Court to issue an injunction order requiring that there is rectification of the register of members. One is the aggrieved person, number two, any member, number three, the company. So these are the parties who can make an application to the court so that the court, specifically the High Court, can issue an injunction or court order demanding the register of members to be rectified. And these are the aggrieved person or any member or the company. Next is closure of the register. The closure of the register. Under Section 117, the company may by notice. Under Section 117, the company may by notice in some newspaper circulating in Kenya or in that part of Kenya which the registered office is situated, close the register of members for such time or times not exceeding an aggregate of 30 days in a year. So you can just close that register maybe for that days, not more than that days. Next, inspection of register. Under Section 115, the register and the index kept at the registered office are open for inspection by members without charge for at least 2 hours every business day, subject to reasonable restrictions as the general meeting may prescribe. All the other persons must pay a prescribed charge. A member who applies for a copy thereof must be furnished with the same within 14 days of the application. It is a criminal offense to deny a member the right to inspect the register and index or refuse to give him copies on request. So that is all about register of members. I believe you have understood the register of members. So the register of members, or you have register of members, you can pause your video and just register of members you have taken from here. Then maintenance of register, then rectification of register of members. Then away from that, this to do with rectification, closure of the register, and inspection of register. You can pause your video and you take up that. Now we move to rights and liabilities of members. Move to the next part, and that is rights and liabilities of members. So next part, move to rights and liabilities of members. Now here, the case in Force versus Aborto will be critical. The case in Force versus Aborto will be critical. Now, we take up the membership rights. Now we have either individual membership rights or corporate membership rights. When it comes to rights, we have either individual membership rights or corporate membership rights. That's quite important. You can take up that individual membership rights and corporate membership rights. Those are important points to note there. I take up that individual membership rights. These are rights conferred by law on members in their individual capacity as members. They are personal rights which can only be taken away by statute or consent. The rights are exercisable by members as they wish and irrespective of the wishes of the majority. If violated, the member has a personal action for redress. So individual membership rights means the rights which belong to the individual themselves. Like for example, a member has a right to attend an annual general meeting. A member has a right to vote. A member has a right to be represented by a proxy. A member has a right to receive dividends. So these are rights which belong to individual members. These are rights which are enjoyed by individual members. We refer to them as individual membership rights. These are rights conferred by law on members in their individual capacity as members. So if you are James and you have shares in company A, there are those rights which are conferred to you as James. Like as I have mentioned, you have a right to attend annual general meeting. You have a right to vote. You have a right to receive dividends. These are rights which belong to you as an individual member. These are rights which belong to you as an individual shareholder. They are referred to as individual membership rights. Then, with corporate membership rights. Corporate membership rights, which is explained in the case study in Force versus Aborto. Corporate membership rights. These are rights conferred by law on members as a group. So we are saying that the corporate membership rights are conferred on the members as a group, all of them. If, for example, we have a company with 20 preference shareholders or 13 ordinary shareholders, then this particular number of shareholders, there are certain rights which they enjoy collectively. There are certain rights which they enjoy collectively. And they are the ones which constitutes corporate membership rights. So we are saying that corporate membership rights are rights conferred by law on members as a group. So whereas individual membership rights belong to an individual person, corporate membership rights belong to the members as a group. They are therefore group rights whose members have to submit their will to that of the majority. The engagement of these rights is governed by the majority rule, which is the rule in Force versus Aborto. If violated, no single member has personal action. However, a representative action is available to remedy the wrong, and the company is made one of the defendants in the case. This case in Force versus Aborto explains it's quite important that just try to understand the spelling here. Force versus Aborto, check the spelling here. This is a very important case study as far as chapter 3 is concerned. Okay, just go through individual membership rights as well as corporate membership rights. You just pause your video and you check that. I move to corporate rights. What are corporate rights? Corporate rights. These are rights conferred upon the company by law and are exercisable by the company as a legal person. If violated, the company is prima facie the proper plaintiff for redress. However, the problem arises where the wrongdoers, whether directors or members, are in control and thus prevent the company from suing them. To remedy such wrongs, the law has developed the procedural mechanism of derivative actions. I will take up derivative actions in a while. However, before we move on, corporate rights. Check this about corporate rights. So this notes, this part here, pause your video, you check these notes here. They are discussing about corporate rights. Corporate rights, whereby by the end of these notes have mentioned derivative actions. Derivative actions. What is a derivative? So these are corporate rights. Now, away from that, I can explain a little bit of the majority rule, which is known as the rule in Force versus Amboto. Now take this now, just go through these notes here from the rule in Force versus Amboto. Check this. The principles that must be present for the rule, the majority rule is also known as the rule in Force versus Amboto. These three must be present. Then the purposes for the rule in Force versus Amboto. Understand these three. Therefore, exemptions to the rule in Force versus Amboto. And then I will discuss that right now. You can pause your video and you go through that. Now, very fast we move to the majority rule, or the rule in Force versus Amboto. You see, it is also known as a majority rule. Remember that when it comes to decision making in companies, decisions are made through voting. They say that the majority have the way. What does that saying go? The majority have the way, the minority have the say, or the majority have the say, the minority have the way. Something like that. Now here, simply, decisions with respect to companies are made through voting, through votes. In financial reporting and analysis, specifically the group accounts, we know the group structures where you have the parent company or the holding company, the subsidiaries, and the non-controlling interest or the minority interest, the associates. Now, when it comes to decision making, then those who have more shares are the ones who have more influence as far as decision making in companies is concerned. If one person has 90% of the shares and the remaining 10% belong to the minority, most of the times it implies that those who have 90% of the total shares, whenever they make a decision and they are voting, they will always be the winner. So the 10% minority will always be the loser in that case. But how can we protect this minority? How can we protect the interests of the minority shareholders? Because when it comes to voting, whether the decisions are wrong or right, then these minority shareholders will always not have any influence as far as the final outcome of the vote, which will influence the decisions of this company is concerned. So company law has put in place certain legal mechanisms to protect the interests of the minority shareholders, to protect the interests, to protect the rights of the minority shareholders, so that they may not be oppressed by the majority shareholders. And in that case, we use the rule in force versus Abuto, or the majority rule. The enjoyment of corporate membership right is governed by the majority rule, under which the will of the majority prevails. The majority rule is the rule in force versus Abuto, which describes the policy of the courts not to interfere with internal affairs of the company. So you're saying that even though the minority may always be oppressed by the majority when it comes to decision making, and again, the law requires the courts not to interfere with the internal affairs of companies. That's the point. For this rule to apply, the following three principles must be present. So for us to apply the rule in force versus Abuto, these three principles must be present. One, proper plaintiff principle. You can say plaintiff or plaintiff. Some pronounce the term as plaintiff or plaintiff. You have the double F silent. Proper plaintiff principle. When a wrong is done to a company, the company is prima facie the proper plaintiff for interest. So for the rule in force versus Abuto to apply, there has to be proper plaintiff. Number two, internal management principle. The courts of law will not interfere with the internal affairs of the company. And number three, a member of a company cannot sue to rectify any irregularity or informality which the company can, by its members internally, correct. These are important notes here. Principles that must apply for the rule in force versus Abuto to apply, or the majority rule. So these three principles must apply. Principles to apply for the rule in force versus Abuto to apply. Those three. Let's have the purposes. The purposes for the rule in force versus Abuto. The purpose is one, it enhances democracy in the internal management of the affairs of the company. Number two, it reasserts the rule in Salmon versus Salmon that a company is a separate legal entity. Number three, it prevents multiplicity of actions filed on behalf of the company by other persons. And number four, it prevents petty actions on matters which can be resolved internally. Then exemptions to the rule in force versus Abuto. Exemptions, number one, if the act is ultra vires, we said ultra vires means in excess of the powers given. Refer to our previous classes in chapter 2. So exemptions to the rule in force versus Abuto, number one, if the act is ultra vires. Number two, where the act is illegal. Number three, in case of violation of individual membership rights. Number four, in case of fraud on the minority. Number five, in case of oppression of the minority. So understand the purposes for the rule in force versus amplitude and exemptions to that particular rule. You can pause your video and you go through that. Important notes here. The purposes for the rule in force versus amplitude, the purposes, and exemptions to that rule. Understand the purposes and exemptions. Now we go to minority protection. Minority protection. Go to minority protection. As a general rule, company affairs ought to be managed in a democratic manner in accordance with the articles and the law. That's the Articles of Association. As such, the majority rule prevails and the courts only interfere if the majority decision arrived at, in accordance with the law or articles, are actuated by bad faith or benefit the majority only. Company law attempts to champion minority interests through judicial propositions. Minority protection. We've said that in companies, decisions are made through voting. Definitely, you have the majority shareholders and minority shareholders. So in that case, when it comes to decision making, those who are few in number, may be oppressed, because there will be no time when their votes will be of any significant influence when compared to the votes by the majority. Minority protection at common law. That's what we want to check. How do we protect the minority? We can either have protection of the minority at common law, as well as minority protection by statute. So there are two things that we should check there. Minority protection. Can you go through this? Just you pause your video and you go through this. Minority protection here. Check these notes here. You pause your video and you take this. Then minority protection at common law. How do we protect the minority at common law? One, majority decisions made in bad faith may be challenged before a court of law. So if a decision has been made by the majority shareholders, but the same is in bad faith, then this can be challenged by the minority in the court of law. By so doing, we are protecting the minority. That's one way of protecting the minority at common law. That is, majority decisions made in bad faith may be challenged before a court of law. Number two, majority decisions made in contravention of the articles. When you talk of articles, we mean articles of association. Majority decisions made in contravention of the articles of association or regulations of the company may be challenged before a court of law. And number three, although company law cannot prevent the majority from voting selfishly, they must always do so in the best interest of the company. Majority decision must be set aside if its objects or purpose is one, to benefit the majority at the expense of the minority, and number two, to facilitate expropriation of corporate assets. I'll just take you back again because these are important areas. Protection of the minority at common law. Minority protection at common law, number one. You check number one here. Then you move on to the next part. That's number 2 and number 3. And also you know this. So this is protection of the minority under the common law. After that, now we move to minority protection by statute. Can you pause your video and go through this? Alteration of the object clause, variation of class rights, convention of the AGM in case of default, requisition of an extraordinary general meeting, convention of a general meeting pursuant to court order. These are numerous. Minority protection by statute. We've seen 3 ways of protecting the minority through common law. Now we are looking at protection of the minority interest by statute. Now I go through them very fast. So through statutes, one is the alteration of the object clause. When we are changing the object clause, we say that object clause is found in the memorandum of association. The purpose of object clause is to indicate the purpose for which a company was incorporated, the economic activities which the company was incorporated to engage in. Registered companies, as we said, should engage in those activities found in the object clause, while statutory institutions should engage in those activities contained in the Act of Parliament creating them. Now, you cannot just change the object clause without going through the voting process. The majority will vote, the minority will vote. However, what if we are changing the object clause and the minority are not comfortable with that arrangement? Now, this is how we will protect the minority interests in the circumstances in which we are changing the object clause. Alteration of the object clause. Under Section 8, subsection 1 of the Act, a company may, by special resolution, alter the object clause of the memorandum. However, the proposed alteration may be objected to by the minority. How can that one be objected? Whereas we are saying that a company may change the articles of association, that is the object clause which you find in the MOA. But such may be objected by the minority. How? One, holders of not less than 15% of the issued capital. So such an alteration may be objected by holders of not less than 15% of the issued capital. Number 2, holders of not less than 15% of any class of shares. Now we'll be looking at class of shares. So this means either ordinary shareholders or preferred shareholders. And number C, not less than 50% of the company members. The alteration may be cancelled by the court at the instance of the majority. So in that case, you will be protecting the minority interests by statute. That is when making alteration of the object clause. Number 2, variation of class rights. How do we protect the minority interest with respect to variation of class rights. A class here means either preference shareholders or ordinary shareholders. A class. Class here means that the interests of the members are too similar that they can consult. When you talk about class of shares, we mean that these shares or the shareholders of these particular shares, their rights are too similar that they can consult. Preference shareholders, for example, all preference shareholders, we can call that a class of shares. Ordinary shareholders, that's a class among others. So, variation of class rights, you are varying the rights of a particular class of shareholders. Like, for example, preference shareholders should always be the first to receive dividends. We can't change that. If they are receiving maybe 7% preference shareholders in terms of dividends, then can we change this 7% to 5%? That may not be the case. So how can we protect this variation of class rights? The rights associated with certain shareholders being changed and the minority are not comfortable with that arrangement. Variation of class rights. Under Section 74, subsection 1, a company whose capital has been divided into different classes of shares may vary the rights attached to any class by special resolution or written consent of not less than 1/4, or just a quarter, of the holders of the shares. However, the variation may be disallowed by the court upon application within 30 days of the consent of resolution by the holders of not less than 15% of the shares who did not consent or vote in favor. Number 3 is convention of the AGM in case of default. The other protection. Under Section 1.1, subsection 2 of the Act, if a company fails to hold an AGM in accordance with the Act, any member of the company may petition the registrar to convene or direct the convention of the AGM. Such an AGM is duly constituted by one member present in person or by proxy. A proxy is a representative. Number 4, requisition of an extraordinary general meeting. Under Section 1.2, subsection 1 of the Act, an extraordinary general meeting may be convened at the option of the minority. The requisition may be made by holders of not less than 1/10 of the paid-up capital or the total voting rights of the company. If directors could not convene a meeting within 21 days of the requisition, the requisitionists or not less than 1/2 of them may convene a meeting. Number 5, convention of a general meeting pursuant to court order. Under Section 1.5, subsection 1 of the Act, if for any reason it is impractical to convene or conduct a meeting in accordance with the articles and the law, the court may order its convention upon application by a director or any member entitled to attend and vote. Such a meeting is duly constituted by one member present in person or by proxy. Number 6, investigation of an inspector or inspectors. Under Section 165, subsection 1 of the Act, the High Court may appoint one or more competent inspectors to investigate the affairs of a company upon application by the members. The application may be made by one, not less than 200 members. Number 2, holders of not less than 1/10 of the issued shares. Number 3, not less than 1/5 of the number of members in the register. Number 7, takeover bid. We did takeover bid last time in chapter 2, that is lifting the veil of incorporation. We gave the case study in Bango Press. So in case of takeover bid, how do we protect the minority interests? When the majority has formed a new company, to enable them acquire the minority interest, the dissenting shareholders may petition the court within 1 month of the notice for cancellation of the takeover bid, and the court may disallow it. So you know what takeover bid is. You can revisit the case in Bango Press. We just go to chapter 2, where we have discussed about lifting the veil of incorporation. Then last, number 8, winding up under the just and equitable grounds. Under section 219, subsection 1 of the Act, act here means a company act. A company may be walled up by the court if it's of the opinion that it's just and equitable that the company should be walled up. The minority may instigate the winding up of the company on this ground in case of oppression or where they have justifiably lost confidence in the management of the company affairs. Now, those are important points as far as minority protection is concerned. Now, I just want to remind you that there are 2 ways in which you can protect the minority interest, and one is through common law, and the other part is minority protection by statute. So understand it that way. So under the minority protection at common law, you just mention this minority protection under. So take this point here, minority protection at common law. We have 3 of them. 1 is there. Then we have number 2 and 3. Then you check minority protection by statute. We've discussed that. So take up alteration of the object clause. When you are altering the object clause, how can we protect the minority interest? Then variation of class rights, how we protect the minority interest when we want to vary the class rights. I've mentioned what a class is. Class of shares constitutes of shares where the shareholders, they have their rights are too similar to enable them to consult one another. Protection under when convening AGM in case of default. Protection when you are convening an extraordinary general meeting. Protection when you are convening a general meeting pursuant to court order. All these are ways of protecting the minority by statute. Then we also have number 6. Protection of the minority under statute. Investigation of an inspector or inspectors when there is during the takeover bid. Refer to the case in Bango Press in chapter 2, lifting the veil of incorporation, and then when winding up under the just and equitable grounds. Away from there, rights of members. Can you check the rights of members? A member is a shareholder. Rights of members. What are the rights of members? Right, now we have seen some individual rights and corporate rights. We just discussed that a few minutes ago. We have discussed that a few minutes ago. Individual rights. The rights available to an individual member. And corporate rights, rights confined or conferred on the members as a group, which is elaborated through the case study in Force versus Abbott. So some rights of members here are right to receive dividends when they are declared in that class of shares. Members or shareholders have a right to receive dividends when they are declared, either preference dividends or ordinary dividends. Right to receive notice of the meeting. We'll be coming to meetings, types of meetings, like what we are mentioning here, annual general meetings. So right to receive notice, right to attend the meeting and vote at such meetings, right to transfer shares. I've mentioned what it means by transfer of shares and transmission of shares. Right to receive bonus shares and other benefits when they are declared. Bonus means shares issued to the existing shareholders for free. Right to inspect minutes of general meeting and register. You looked at inspection of register of members, so they have a right to inspect that register. In the event of winding up, after the payment of all other debts, the right to receive assets which are distributed to the members. Those are some of the rights of members. They are not only this, there are other rights. There are so many in number. But you can classify them as either individual rights or corporate rights. I just go and find out. You can analyze a list of individual members' rights and corporate members' rights. Now from there, we move to something else, and this is cessation of membership. We have cessation. How do we write cessation? Cessation of membership. From the word to cease, to stop. How do you stop from being a member? If you want to understand cessation of membership, how to stop from being a member, first understand acquisition of membership. How do you acquire membership in a company? So once you understand how to acquire membership, then this one now becomes quite easier. So first understand that before you come to that. If you have understood how to acquire membership of a company, then ceasing now becomes easier. Now there are a variety of them here, which I will present to you, and then I'll discuss them very fast. So how to cease from being a member? How do you stop from being a shareholder? I'll give you a list of that. Transfer. Cessation, you can stop. The cessation of membership. How do you stop from being a member? How do you stop from being a shareholder in a company? 1, transfer, death, bankruptcy, repudiation of an infant, disclaimer by trustee in bankruptcy. The list continues. Forfeiture, surrender of shares, liquidation or winding up, rescission of contract, redemption of redeemable preference shares. Those are the 10 ways. Those are the 10 ways in which you can stop from being a member. You can pause your video and you go through them, read and you understand before I discuss them. You can first read them. Don't forget my number down there. Transfer. So how to stop from being a member. You pause your video and you go through this. Those 5. And they continue from the other side up to 10. So stopping from being a member. 1. Transfer. I've said differentiate between transfer and transmission. Transfer is voluntary, like when you are purchasing shares from an existing shareholder, not from the company. That's a transfer. Transmission is involuntary, like in case of death or in case of bankruptcy. So death, that's a transfer, is one of the ways of stopping from being a member. Transfer. This occurs, but before that, I read that statement which is up there. When a person ceases to be a member, his name is removed from the register of members. A person ceases to be a member of a company in the following ways. You stop from being a member in the following ways. One, transfer. This occurs when an existing member sells all the shares to a third party. Remember, transfer, you are selling your shares. In this case, there are two ways in which you can sell your shares. Either full transfer or partial transfer. If you make a partial transfer, you are not selling all your shares. So in that case, partial transfer will not result to you ceasing from being a member. The only transfer which can result to you ceasing from being a member is full transfer. You are selling all your shares to the other person. The transferor is transferring all the shares to the transferee 100%. So transfer of shares. Once you transfer your shares to the other person, your name should be removed from the share register. And the name of the transferee is now entered into the shares register. So in this case, one person ceases from being a member, and the other person now becomes a new member. You see here, acquisition of membership and then cessation of membership here. So in case of transfer, that is full transfer, if you transfer all your shares to the transferee, then you stop from being a member, you cease from being a member, and the transferee acquires membership. That's why I've said, understand the acquisition of membership and the cessation of membership. So transfer is one of the ways in which you stop from being a member. This occurs when an existing member sells all the shares to a third party. The third party will become the new member of the company, while the transferor ceases to be a member of the company. So transfer. Number 2, death. Obviously, if a shareholder passes away, that person stops from being a member. So death. When a person dies, his membership of a company comes to an end automatically by the virtue of the provisions of the law of succession. So death brings your membership to an end. Number 3, bankruptcy. When one becomes bankrupt, his membership will come to an end under the provisions of Bankruptcy Act, and his shares will be transferred to his trustee in bankruptcy. So bankruptcy. Number 4, repudiation by an infant. An infant has a common law right to repudiate his ownership during his infancy or within a reasonable time upon attaining the age of majority. I think you have done the law of contract and you understand what we mean by repudiation by an infant. Number 5, disclaimer by trustee in bankruptcy. Under the common law, if a trustee in bankruptcy refuses to take up the shares of a discharged bankrupt, he or she ceases to be a member. Number 6, forfeiture. When the company articles of association authorizes the director to forfeit shares, and the director forfeits all the shares held by a member, the member will cease to be a shareholder from the date specified in the Articles of Association as the effective date of forfeiture. Number 7, surrender of shares. A person's membership will come to an end if he surrenders all his shares to the company with the approval of the directors. Number 8, liquidation or winding up. Liquidation automatically brings to an end the membership of all the members from the date when the liquidation becomes effective. Number 9, rescission of contract. A shareholder who resigns or avoids a contract of purchase of shares or allotment by reason of vitiating elements, e.g., false statement in the prospectus, ceases to be a member. And lastly, number 10, redemption of redeemable preferred shares. To redeem is to purchase back. Redeemable preferred shares are those shares which can be purchased back by the company in the future. If a person held redeemable preferred shares and all the shares are redeemed by the company, he ceases to be a member from the date on which his name is removed from the register of members. Now, those are important points concerning how to cease from being a member. How do you stop? How do you stop from being a member or a company member? How do you stop? How do you stop from being a shareholder? Those are important points for you. Just go through them. Cessation of membership. How to stop from being a member. How to stop from being a shareholder. By transfer, by death, by bankruptcy, repudiation by an infant, disclaimer by trustee in bankruptcy. You pause your video and you go through these important points there. You go to number 6. On the other side, you have forfeiture, you have surrender of shares, you have liquidation or winding up. That is when the company has come to an end. If the company collapses, then there is no shareholder. You all stop from being shareholders. Rescission of contract and redemption of redeemable preferred shares. Okay, from there we are moving on. Now, let me check what we are supposed to go through. Okay, so cessation of membership, we have done that. We go to register of a company's beneficial owners, which I believe we do not have much there. Register of company's beneficial owners. Can you go through that? Register of members, register of directors and secretaries, register of directors' interests, register of chances. Can you go through that? Can you go through that? You can as well continue from the other side. You have got that. Can you go through all that? Pause your video and go through that. Now, register of a company's beneficial owners. I didn't check register of members, register of directors and secretaries, register of directors' interests, register of chances. Every company shall keep a register of its directors. I've done the register of members, so we know what register of members is. Was there a register of members? We know what it is. Now, as you progress, because you'll be covering directors, secretaries, and auditors, when we come to directors now, we'll look at register of directors. Now here we have just briefly mentioned that every company shall keep a register of its directors. A company shall ensure that its register of directors complies with sections 135 and 136. A company shall keep its register of directors open for inspection at its registered office or at some other place prescribed or authorized by the regulations. A company shall ensure that its register of directors is kept open during its ordinary hours of business for inspection by 1. Any member of the company without charge, and B. Any other person on behalf. Take that one again. Any other person on payment of a fee, if any, not exceeding the amount prescribed. If a company refuses to allow a person to inspect the register, that person may apply to the court for an order under subsection 6. A company's register of directors is required to contain the following particulars in respect of a director who is a natural person. So, the register of directors should contain the following. We've discussed what you find in the register of members, the contents of the register of members. Now, here we are saying the register of directors should contain 1. The person's name and any former name. Number 2. Service address. Number 3. The country or state or part of Kenya in which the person is usually resident. The person's nationality. The person's business or occupation, if any. The person's date of birth. For the purpose, or before that, you can just check what you find in register of directors. You expect the register of directors to contain these details. The register of directors. However, we'll be coming back to that as we progress. We have chapters which cover directors. We have chapters which cover secretaries. We also have changes. We have a chapter which covers changes, more about changes. We are just briefly mentioning that at this point here. However, you can just check what you expect to find in the register of directors, these A to F. For the purpose of this section, what are we being told? For the purpose of this section, I can just go through that. For the purpose of this section, name means what? Former name means what? That's what we are discussing there. And I am told, for the purpose of this section, name means a person's forename and surname. And former name means a name which the natural person was formerly known for business purposes. If a person is or was formerly known by more than one such name, each of them has to be stated. It is not necessary for the register of directors to contain particulars of a former name if the former name 1 was changed or disused before the person attained the age of 18 years or has been changed or disused for 20 years or more. And number 5, a person's service address may be stated to be the company's registered office. We move on to derivative actions. We move on to derivative actions. We move to derivative actions. I mentioned that somewhere. Derivative actions. An assignment for you. Go to artificial intelligence or chat GPT and ask her what is a derivative action with respect to company law. What is a derivative action? Can you go through that? Can you go through my notes? I've given you that as an assignment. You can use your smartphone or your computer. You ask, what is the meaning of derivative action as used in company law? Now, this is what I've written here myself. This is an action instituted by a shareholder in his name on behalf of the company to remedy a wrong done to the company. Just a few minutes ago, we discussed about individual members' rights and corporate rights. Now here, we are defining derivative actions or derivative actions. This is an action instituted by a shareholder or a member in his name on behalf of the company to remedy a wrong done to the company. It is representative in character and remedies individual violation of corporate rights. It is available for the enforcement of duties owed to the company as opposed to the members. It ensures that wrongs done to the company are remedied even if the wrongdoers are in control of the company. However, for the action to be instituted and sustained, the following conditions must be fulfilled. 1. Fraud. The contact complaint of must involve some fraud on the minority, e.g., unfair use of majority voting powers. Number 2, it must be evident that the wrongdoers are in legal control of the company. Derivative claim means proceedings by a member of the company in respect of a cause of action vested in the company and seeking relief on behalf of the company. A derivative claim may be brought in accordance with an order of the court in proceedings for protection of members against unfair prejudice brought under this Act. A derivative claim under this part may be brought only in respect of a cause of action arising from an actual or proposed act or omission involving negligence, default, breach of duty, or breach of trust by a director of the company. A derivative claim may be brought against the director or another person or both. It is immaterial whether the cause of action arose before or after the person seeking to bring or continue the derivative claim became a member of the company. For the purpose of this part, director includes former director. Reference to a member of a company includes a person who is not a member, but to whom shares in the company are being transferred or transmitted by operation of the law. So the most important thing here is for you to know what is a derivative action. Just check. You can find out a different meaning when you are doing your research. What is a derivative action is used in company law. But I have mentioned what it is. I'm not saying that I don't know what it is. I've just said what it is, and you mentioned it earlier on. It arises with respect to corporate rights. We have already discussed individual members' rights and corporate rights. So derivative action is an action instituted by a shareholder in his name on behalf of the company to remedy a wrong done to the company. Now we move on now. Those who may become a member of the company. Who can become a member? Who can become a company member? Who can become a company member? Who can become a company member? Those who may become members of company. Now we have infants or minors, adults, personal representatives, trustees in bankruptcy, and body corporates. These are the ones who can become a shareholder. Who can become a shareholder? Who can become a member? Can you go through that? Those who may become members of a company. Infants. Infants are also known as minors. Infants, an infant can become a member. Then we have adults. Adults can become members. Personal representatives, trustees in bankruptcy, and body corporates. Those five can become members. Those five can become members. So who can become a member? Those who may become members of a company. One, infants or minors. Unless the articles provide otherwise, an infant may become a member of a company. However, the contract of membership is voidable during infancy or within a reasonable time after attaining the age of majority. By avoiding the contract, the infant ceases to be a member. I think you have done a cessation of membership. How you stop from being a member? We mentioned something there about these infants. How to stop from being a member? Which point was that? Cessation of membership. Check that. We talked about repudiation by an infant. That was point number 4. Cessation of membership. We said one is number 4 was repudiation by an infant, whereby we say an infant has a common law right to repudiate his ownership during his infancy or within a reasonable time upon attaining the age of majority. So here we are looking at those who may become members of a company. So an infant, a person who is below 18 years, a person who has not attained the age of majority may become a shareholder, may become a member, but with a right to repudiate that contract upon attaining the age of majority or within a reasonable time after attaining that particular age. So infants or minors can become company members. And we say, unless the articles provide otherwise, an infant may become a member of a company. However, the contract of membership is voidable during infancy or within a reasonable time after attaining the age of majority. By avoiding the contract, the infant ceases to be a member. By avoiding the contract, the infant ceases to be a member. Given ways of stopping from being a member. So, number 2 is adults. These are people who have attained the age of majority. These are persons who are over 18 years. Their contract with the company is binding and enforceable by either party. These members are liable to pay costs and all other liabilities arising on the shares held. So adults. Number 3, personal representatives. These are the persons to whom the shares of a deceased member pass to by the operation of the law. Such a person will become a member when his name has been entered in the register of members. So we have personal representatives. Number 4, trustee in bankruptcy. These are the persons to whom beneficial interests of shares of a bankrupt member pass to. He becomes a member when his name is entered into the register of members. So trustee in bankruptcy. And number 5, body corporate. These are artificial persons such as registered companies and statutory corporations. A registered company may become a member of another if authorized by its memorandum. A statutory corporation can become a member of a company if authorized by the statute creating it with a written consent of the treasury. So those are the persons who can become members of a company. Who can become a member of a company? A member is a shareholder. You say infants or minors, adults, personal representatives, trustees in bankruptcy, then body corporate. You mean that? Seeing is believing. I presented that. Who can become, those who may become members of a company, infants or minors is number 1. The other, who can become a member, adults, personal representatives, trustees in bankruptcy, body corporates. There are questions there. You want to check them. Maybe you can check them. Can you answer November 2019? Question 1A. This is a simple question. In relation to the membership of a company, highlight 6 ways through which a person might cease to become a member of a company. Can you answer that? Can you answer that? Can you answer this one? May 2018, question 5B. There's a question here. Describe 3 ways that in relation to membership of a company, describe 3 ways through which a person might become a member of a company. You can just answer that and that is it. So I think we have come to the end of that. Your syllabus requires you to go through acquisition of membership, register of members, rights and liabilities of a member, cessation of membership, register of a company's beneficial owners, derivative actions. Here we have the case in Force versus Amputo. That's important. That's important case to understand. So we've gone through acquisition of membership, how to become a member. So we are through with chapter 3. So next time we'll be moving to chapter 4. So chapter 3 was about membership of a company. The most important area is acquisition of membership. How to acquire membership. We discussed those areas, acquisition of membership. We've asked them how to acquire membership. A member is a shareholder. subscribing to the memorandum of association by application and allotment, transfer from existing member, transmission on death of a member, transmission on bankruptcy of a member. These are ways of acquiring membership. Then we have compliance with section 182 subsection 2 and by estoppel. So those are ways of acquiring membership. Then register of members, we have that, we have maintenance of a register, rectification of a register, we've gone to closure of the register, inspection of register, rights and liabilities, we have individual membership rights and corporate membership rights. The case in Force versus Amputo, very important. Then some corporate rights. We check some corporate rights. Corporate rights, we've done that. Corporate rights, the majority rule or the rule in Force versus Amputo, principles to apply here. The purpose for the rule in Force versus Amputo, exemptions to the rule in Force versus Amputo, minority protection can either be at common law or by statute. At common law we are free. By statute we have a variety. It's a protection of the minority. Here we have 1, 2, 3, 4, 5. It goes on the other side. Protection of the minority. We have protection of the minority up to number 8. Rise of members. Remember, we can have individual members, rise of corporate rights. Cessation of membership. How do I stop from being a member? Transfer, death, bankruptcy, repudiation by infant, disclaimer by trustee in bankruptcy. We have there are 10 of them. How you stop from being a member: forfeiture, surrender of shares, liquidation or winding up, rescission of contract, redemption of redeemable preference shares, register of company's beneficial owners. For register of members, we've covered that. Directors and secretaries, we have mentioned a few things there. We'll be coming back to that later. Then we have ending heirs. We didn't complete through derivative action. Check what is derivative action, and you ask your artificial diligence what is derivative action with respect to company law. Lastly, those who may become members of a company. We have infants or minors. We have adults, personal representatives, trustees in bankruptcy, and board corporates. Okay, I think that's enough. That's enough for that. Unless you have a question, if you have a question, you can ask. So that is it about chapter 3 of company law. We had done Chapter 1, we have covered chapter 1, which was about nature and classification of companies. We've done formation of companies. Now we have done membership of a company. Now next time, chapter 4 now, we move to chapter 4, and that will be shares. So we're moving to chapter 4, and chapter 4, you'll be dealing with shares. That will be our next class for company law. So in chapter 4 will be about shares. That is where we'll be moving to, and we'll be discussing classes of shares, variation of class rights. I've said what class of shares is. Class of shares means that the rights of these shareholders are too close that they can consort. So if you look at class of shares like preference shares, ordinary shares, deferred shares, and such. So we'll be looking at classes of shares, then variation of class rights. We have mentioned something about variation of class rights with respect to protection of minority interests or the minority rights, or the case in Force versus Amputo. So variation of class rights, then share certificates. I mentioned share certificate last lesson. In chapter 2, we did what share certificate is, the meaning of it. So again, we'll be mentioning something more about share certificate. Then issue and allotment. You mentioned about application of shares and the allotment, how to become a shareholder, how to become a member by application and allotment. So you will be looking at the issue and allotment, then transfer and transmission. Again, you have mentioned that. What transfer is? Transfer of shares is voluntary, like as in when you purchase shares from an existing shareholder, that's a transfer. Note that with a transfer, you are not purchasing from the company, you are purchasing from an existing shareholder. So transfer and transmission. Transmission is involuntary, as in, for example, death of a shareholder. That becomes a transmission. Or bankruptcy. That becomes transmission. So we look at transfer of shares and transmission of shares. Then transfer of shares under central depository system. And lastly, mortgaging and changing of shares. So chapter 4, I can just present that to you so that you can start preparing in advance. So we have already done membership of a company. So we'll be looking at chapter 4 now. Chapter 4, that is shares. We'll be looking at classes of shares. You can check from here, chapter 4. It's about shares. So we'll be looking at classes of shares. From there, we'll be moving to variation of class rights. Variation of class rights. Then share certificates. Then issue and allotment. Transfer and transmission. Then transfer of shares under central depository system. Then mortgaging and changing of shares. That is what we will be doing. That is what we will be doing. Next lesson, that is what we will be doing next time. So I think that's enough for that. So we are through with the chapter 3. We are through with chapter 3 of company law. So I've said we have done chapter 1, chapter 2, chapter 3. We'll be moving to chapter 4, which is the shares. So My numbers are 07278710 or plus 254 7278710 93 0727871093. So my name is Mr. Williams. In case you need compound law study text or revision book, you can ask through that particular number. So again, subscribe to our YouTube channel so that you may continue to get these classes as and when we upload them. Again, if you have not been following, just get into our YouTube account, Fatima Institute, and you can have access to chapter 1, chapter 2, chapter 1 and chapter 2, and the whole of chapter 3. So you have covered the entire chapter 3. Again, you may need some classes if you are around Vika town. If you are around Vika town and you need some classes, you can still call us and we can make an arrangement on how we can assist you. If you are far away, we can still have online classes for you. So let's bring that discussion to an end, and we'll pick from there. Next lesson, chapter 4. Thank you for viewing. We'll meet again, God willing. Thank you.